Welcome, Balindile. Balindile is going to talk to us about employment issues in the new world. Just a quick introduction of who Balindile is. Balindile is a director at ENS in the Employment Law Department. She specializes in South African employment law related matters and has experience in drafting opinions related to issues arising from the Labour Relations Act, the Basic Conditions of Employment Act, and the Employment Equity Act. Balindile, over to you, and thank you for gracing us with your presence.
Thank you very much, Newa. Good morning, everyone. As I've said, part of what I'll be looking at is the new world, the work as it's now been called. One of the themes coming out from the COVID-19 pandemic has been remote working or working from home or flexible working. I myself prefer calling it working remotely, but a rose by any other name is still a rose. Even though this has become a heightened topic during our experiences of COVID-19, it's important to note, and the HR-facing colleagues amongst us will know that a lot of organizations had been investigating and dabbling in flexible work measures. But what really has happened is with us being plummeted into level 5 lockdown in March 2020, it has brought remote working to the forefront of a lot of strategy considerations in most organizations. The concept, what this has really done is that it's altered the concept of what it means to be in the office, what it means, what are normal working hours and the like. And what has had to happen is that there's had to be a lot of adaptation. And of course, a lot of employees are quite happy to be spared having to work, having to travel to the offices. So that kind of time that is saved is welcomed by most employees. The costs of petrol, etc., that is being saved is welcomed by employees. But what the research is showing is that at the very same time, because of the encroachment of working hours into personal hours of family time, that is causing some bit of tension in relation to the working from home or working remotely, as it is often referred to. On the other hand, from an employer perspective, the employers are quite happy in the sense that they are getting quite a lot of mileage from the employees, especially those employees who are minded to pens down at 5 o'clock and then only be seen the following day. So with the working from home or that kind of flexibility, employers are getting more value for their money, so to speak. But at the same time, there is a consciousness that office culture or corporate culture is developed in the office. And so there is a concern on the development and maintenance of office culture. So it seems that those are some of the tensions that most organizations are considering when deciding whether or not remote working is a suitable option for their businesses. What I'll try and do during this hour is try to unpack some of the key issues we think that employers should be taking into account when they are deciding whether or not remote working is a suitable alternative for them. Notably, there isn't a single piece of legislation in South Africa that one can look at that regulates remote working. But what we have to then do is look to the different instruments that regulate employment law and take the relative or applicable components and piece together what would then be the regulatory framework of remote working. Naturally, the starting point would be the contract of employment. And what we encourage employers to do is consider the terms or the provisions of the employment contract and see whether they permit remote working or whether they are restrictive and limit the provision of services by employees to the physical office. If they permit remote working, it's also important to see in what way is it permissible, what are the limitations if any. So is it at the instance of the employer, or is it at the instance of an employee, or does it require consultation before a decision can be made as to whether or not employees will be required or permitted, for that matter, to work from home? The next issue then for consideration is once you've seen that you are able to work remotely because your contract provides for it, or if your contract doesn't provide for it, you have taken the necessary steps to amend the contract, which would require the consent of the employees. Then you need to assess what is the appropriate work model for you. Are you looking at a hybrid model where there is flexibility between working at home and working at the office, i.e. employees or the employer can choose at any given time which model they want to move into? Or you're looking at employees will work in a week, for example, 2 days at the office and 3 days remotely, or vice versa, whatever combination really suits the organization. Or whether you actually think that actually, given our type of workforce and the type of work that our organization does, actually remote working won't be appropriate. All of these are the kind of stuff that you need to talk about. And also then identifying the right categories of employees that can work remotely. For example, one would imagine that if you are in a restaurant environment, it will be very difficult to have the chef, for example, work remotely. Don't suggest that it's not possible. I've seen much things in my lifetime now that I thought were not possible. But that kind of category of employees would have great difficulty working from home, for example. So it will also be that kind of exercise where you identify for which category of your employees remote working is sensible. What is important is this exercise, in undertaking this exercise, there must be a fair, objective, and rational mechanism in doing so, because this could be seen as a benefit, or if it's not properly dealt with, it could give rise to direct or indirect unfair discrimination. Just by way of example, a lot of employees are now considering changing their workforce to only be a remote working workforce. So they are considering whether in the job advertisements, for example, they should not have a requirement to say that only those persons who are able to work remotely should apply. So whilst it seems like a fairly objective criterion, because this is what you want to, this is the culture, the working model an employer may want to adopt, there may be some pitfalls embedded in there. By way of example, in order to work successfully remotely, you'll need access to connectivity, internet connectivity. You need access to stable electricity, which is something that we are struggling with at the moment as South Africans. What that invariably means is that employees who come from poor neighborhoods, for want of a better term, or neighborhoods that are not well serviced in these areas, then might find themselves not able to participate or to be eligible for that particular job opportunities. Even though they are applicants, in terms of the Employment Equity Act, they are to be treated as employees and are entitled to the same protections as employees from an unfair discrimination perspective. Invariably, this would be employees from the historically disadvantaged groups. And as a result of that, you might find yourself facing indirect discrimination. So if you are an employer that's looking at that kind of model, what you would want to build in to that framework is accommodation measures where employees are not well resourced to be able to work from home. So this would involve providing them with suitable internet connection, or subsidizing that, and where necessary, where load shedding could be a component, or where there's not a steady supply of electricity, My apologies, everyone. I think I'm back now. I appear to have been temporarily converted into an attendee status. Perhaps what I was presenting did not receive favor. So anyway, as I was saying, I think where I got cut off, I was saying that what one really needs to do is consider the kind of impact that this could have indirectly or on certain groups in the population, and then take measures to accommodate those kind of applicants or those employees so that they are not left out of the job market. The next issue for consideration is data protection, confidentiality, and IT security safeguards. It's going to be important that employers who are minded to permit or require remote working have the right IT infrastructure to protect themselves from a cybersecurity perspective, and also that they have the right mechanisms and platforms from a protection of personal information. We all know that POPIA is now fully enforced, and one would not want to fall foul of that. So training is going to become an important component to employees who are working remotely on those particular issues. Then there is the all-important issue of confidentiality. When employees are working remotely, it could very well be that in an employee's household, one of their relatives or family members works for the employer's competitor. And you would want to make sure that you can manage that. How do you then ensure that the company's confidential information, trade secrets, and the like and IP and the like are protected? In that, do you insist on a clean desk approach? Do you provide the employees with headsets so that when they are in conference calls, that there is a preservation of integrity of the discussions that I had and strategy and the like? All of these are the kind of considerations that must go into this, and clear guidelines and policy must be set, we suggest, and employees must be well trained and also be trained on what to do if there has been a breach or if there is a threat to the employer's information. Some of the things that go unnoticed, for example, is how do you dispose of your paper? You know, and because people have been working from home, are people just taking work-related documents and putting them in a dustbin, which can be accessed by persons once it leaves the household? All of those things, which might seem small, but it could be a significant risk exposure in the wrong hands. All of those things are the type of things that need to go into consideration. And also, if it's remote working, are employees only permitted to work at home, in their homes? Can they work at a coffee shop? Can they work in common rooms which are set up for people, for the general public to come in and just as a workspace? And what happens to the security there, you know, particularly from an IT perspective, and also just when calls are happening, etc. Those are all the kind of considerations that must go into be taken into consideration, and appropriate and regular training we suggest must be given to employees on that score. The next question then is equipment allowances and reimbursements. So again, one of the issues that must be given consideration, and this is not regulated by our laws per se, is who is going to pay for the equipment that employees need for remote working? Will there be a reasonable reimbursements of reasonable expenses, etc.? And those are the kind of things that employers need to concern themselves with. I would suggest that if you are operating from a perspective where you as the employer are compelling employees to work remotely, there's probably a better case to be made that there should be some form of, at the very least, subsidization of the employees' equipment that they need, because essentially it is their tools of trade. However, if the remote working is probably more at the instance of an employee, then there might be a case that the employee must ensure that they are suitably set up. But what we are seeing is more and more employers are giving a once-off allowance to employees to set themselves up. And then once the employees are set up, then the employers step back and then they just allow things to work. Then there is the issue of occupational health and safety. In terms of the Occupational Health and Safety Act, a workplace is very widely defined. And a workplace means any premise or place where a person performs work in the course of their employment. So this could very well be, we think, the employee's home. And of course, an employer has certain obligations in terms of the Occupational Health and Safety Act to ensure and maintain a safe working environment and to try as reasonably practicable to eliminate risks to health, etc. But of course, if people are working remotely, there is the impracticality of going into each and everyone's homes to try and ensure that the working environment is suitable. So employers are going to have to be creative about this. Some of the mechanisms which we think work is having a checklist that you send to employees and say, these are the things, my dear employee, these are the things that I think you need to look at. Please consider X, Y, and Z, and look at the economics, look at the lighting, look at ventilation, and then have the employee return that form back and then do an assessment as to whether or not, from a health and safety perspective, the person's particular working environment is suitable. And where it is reasonably practicable, have intervention measures to ensure, as far as reasonably practicable, I keep stressing this, that working environment is safe. The next issue that then becomes important is Withhold performance management. Before 2020, one of the biggest fears from employers was that, well, if a person is out of sight, how do I know that they are working? Can I trust that that they are doing their job and that they are not instead on Netflix the whole day? So performance management becomes quite important. From where I sit, I think that the performance criteria or the performance standards would generally be the same, whether you're working remotely or working at the office, but depending on the nuances of a particular job, there may be some variation. But what is going to have to be very important is there are going to have to be clear discussions regarding performance management and performance expectations. And weekly or monthly catch-ups are going to be very important, and these can happen remotely, or employees can be required to come back to the office at least once a month or every so often during the course of the month, just to touch back and just to get a sense check of the general employee's well-being. And instead of waiting to do just one annual performance review, if that's what is your organization standard, or 2 performance reviews per year, maybe consider more regular performance appraisals and feedback. And even if it's done informally, just so that there is a constant engagement with the employees and management of expectations. Linked to performance management, but not to be confused as the same thing, is misconduct proceedings and disciplinary action. Just because employees are working remotely doesn't mean that the rules of the employer need not be followed. And as I've said, even though this is from the perspective of the Occupational Health and Safety Act, the workplace can be a very broad concept. And even if you are office bound, it is possible for you to commit misconduct when outside of the workplace. So if an employee does anything that brings the employer's name into disrepute, I beg your pardon, then an employer may take action against that. Or also if the employee just commits regular misconduct, but whilst in the performance of their duties, that still is an exposure for the employee, and the employer is still entitled to initiate disciplinary proceedings against that particular employee. The question of how those disciplinary proceedings will take place will depend again on the nature of the remote working at place. So if employees work fully remotely, then it may well be that those disciplinary proceedings will also be conducted remotely. If there's a hybrid, then employees may well come in, but all of that is dealt with on a case-by-case basis, and reasonable flexibility to ensure procedural fairness would have to be taken into account. So with all of that, what are the pitfalls that we are seeing in relation to remote working? There appears to be a sense of that limited interaction is leading in some instances to the alienation of workers, and there's a limited sense of being a part of an organization. And we all, of course, know that that is part of an organization's health. So employers are going to have to pay even more attention to mental health issues and just generally ensuring their employees' well-being, because, of course, that also has a knock-on effect on productivity. There's also the issue of virtual meeting fatigue and working longer hours, and people feeling that they have to be accessible at every minute of every day. And that kind of management, and seeing if you can have general guiding principles on when employees can take some just time off, encouraging employees to take a lunch break, encouraging employees not to send unnecessary emails after hours or over the weekend, if that can potentially wait. Of course, operational requirements are going to have to be taken into consideration. And if something's urgent, it may well be that it's unavoidable. This also then brings us to the issue of working hours. For those employees who earn below the BCA threshold, which is currently sitting at 211,000, just above 211,000 Rand, we all know that from a working hours perspective, those employees cannot be required, well, from ordinary working hours, the ordinary working hours are up to 9 hours if they work a 5-day week, or 8 hours a day if they work more than 5 days a week. So anything above those hours would go into overtime spend. So you also want to make sure that you manage the productivity of those particular employees, and you get as much value and as much productivity from those employees during the ordinary working hours. Otherwise, you're going to have to deal with an overtime bill. So part of the consideration will then be is, to the extent that I have employees who earn below the threshold, who are not managerial employees, can I structure the working day such that I get maximum productivity during the ordinary working hours? Or is that something that is beyond my control and it doesn't work as well when they're working remotely as it does when they are in the office? And that might be a case in certain instances against remote working, but all of those go into the basket of factors to be considered. Then finally, on the issue of remote working, we are seeing a trend of semigration and global mobility. Because employees can now work remotely, what employers have seen is an opportunity to expand their talent pool. So there's no longer a geographical focus or limitation from a recruitment or of talent perspective. And people then are often working from outside the working and providing services outside the jurisdictions in which they reside. All of this is a great opportunities for employers, but what we caution employers to consider is the laws of the receiving country. So consider immigration laws, consider corporate and corporate tax laws, and consider general employment laws to see that there's not a dual employment regime that might be applicable, or a dual employment relationship that might be caused because of that. And if there is, take the necessary steps to manage that. If your employees are going to be permitted to work outside the spaces where they stay, what I would then also suggest is that you have a mechanism where employees report if they are going to be out of town, so that if employees are going to be required at a moment's notice, you can manage and take that into consideration. We are finding that when employees are now being called back to the office, employers are discovering that so-and-so has been working from Mauritius since last year, and now there are difficulties getting them back because certain arrangements have to be made, etc. So those are all part of the considerations that one would need to take into account. So with all that in mind, what is becoming clear to us is that as employers develop their policies and develop their positions on remote working, there's going to have to be clear guidance and policies set in place, appropriate training given to the employees to ensure that everything works, and most importantly, there's going to have to be a measure of objectivity and fairness in determining who gets to work remotely, what benefits are accorded to them, and all those lovely things. So to summarize, if you are looking at remote working, consider the contract of employment. Does it permit it? Does it not permit it? If it doesn't permit it, take steps to amend it. Consider working hours. Are the employees in question limited to ordinary working hours? And if not, then there might be more flexibility. If they are earning below the threshold, consider whether you can get maximum productivity during the ordinary working hours, or whether this may result to an overtime work bill. Consider lunch breaks, and maybe remind employees to say, because you are working remotely, you must take your 1 hour lunch break unless there's an agreement to reduce it to 30 minutes, etc. Consider health and safety requirements, and make sure, as best as you can, that the employees' workplace or workstations, wherever they may be, comply with the requirements of occupational health and safety. Data protection, confidentiality, and IT security are paramount. Make sure that you have the right protections and training. And then finally, have mechanisms to deal with semi-migrations and global mobility. So that is what I have to say. I still have a good amount of time. One of the other issues that I've been asked to briefly touch on is the good old mandatory vaccinations from a COVID-19 perspective. I see there's a lot of comments coming through, so I'm quite keen to take some questions. So I'll just go quickly through the high level points on this issue, and then let's see if I can carve out some good 15 minutes for some Q&A. Right. Now, from a COVID-19 perspective, we are all now familiar with the consolidated directions that were issued in June. And we all know that the primary requirements coming out of that is that all employers must undertake a risk assessment, I beg your pardon, taking into account whether or not employees, taking into account whether or not that employer intends to make vaccinations mandatory. And if the employer intends to make vaccinations mandatory, identifying those employees who must be vaccinated because they are at risk of transmission through work, or suffering severe COVID-19 symptoms, or death due to their age or comorbidities. That risk assessment must then translate itself to a workplace plan. The risk assessment was supposed to be done within 21 days of the issuance of the consolidated directions. There's been some confusion in the market because, and some employers appear to have formed the view that because they are not considering mandatory vaccinations, they are not required to do this risk assessment. That position is not correct. Everyone is required to do the risk assessment, and from that risk assessment, you determine whether or not mandatory vaccinations is appropriate for your workplace or not. I cannot overstress the importance of this risk assessment, because it is the document from which all decisions that you will then make flow, and to the extent that you decide to implement a mandatory vaccination policy, it is the document that will be used as a defense mechanism against any challenges. So it's going to be very important that the risk assessment is well supported by scientific and empirical evidence. So if you take the view that certain employees are exposed from a transmission perspective, have the stats, if you can, to say employees who do this particular work, this is their exposure to the public, this is how much human traffic they are exposed to, this has been the rate of infection amongst this category of employees. When there's an infection, this is what the disruption it causes to my organization. This is how much time off I need to generally give people who have been in contact with an infected person, and this is how much time, and this is the impact that it has. So for example, you have employees who work in teams, and if a certain amount of people in that team are unavailable for work, the team is dysfunctional, that kind of evidence to show the kind of disruptions that are then caused would become important, and to demonstrate why PPE measures are not as effective as a vaccination would be. So why is it that a N95 mask alone does not work well? Or why is it that regular masking does not work well? So all of those evidentiary factors need to be well documented, so that if you are challenged on that, you've got that information readily available, and we are not suddenly running around trying to piece together evidence when we have to be at the CCMA or at the Labour Court, as the case might be, defending that particular position. Once you have decided that you are going to implement mandatory vaccination, the guidelines also give some guidance as to what is it that employers must do. So for example, in terms of the guidelines, employees who to be vaccinated must be notified of the obligation to be vaccinated as and when vaccinations become available. The position in South Africa has changed dramatically from June to now. Vaccinations are now more readily available. They must be advised of their right to refuse to be vaccinated on constitutional grounds or on medical grounds, and be given an opportunity to consult a health and safety representative or worker representative or a trade union in relation to this particular issue. The most important question is what happens if an employee refuses to work after you as the employer have done your risk assessment, you've got the right evidence, and you've taken the decision that mandatory vaccination is appropriate for my particular workplace. The guidelines again come in and they say you must provide that employee with counseling if it's requested, allow the employee again to see, as I said, to seek guidance, refer the employee to further medical evaluation if there is a contraindication for vaccination, and then take reasonable steps to accommodate the employee in a position that does not require the employee to be vaccinated if necessary. And this then brings us to the accommodation steps. From an accommodation perspective, what the guidelines and the consolidated direction are clear on is just because an employee is unable to be vaccinated or is refusing to be vaccinated, it does not follow that they must be immediately dismissed. And that is the one caution that we are giving to all our clients and all the employers. You need to carefully look at the reasonable accommodation. Can you modify their job or the working environment? So can they work remotely, for example? Can they work after hours when there's not as much traffic in the office? Can they work in isolated spaces where there's not exposure to other employees? It's not a closed list, but you'd have to look at all those things. And if those things are not going to work, so they're going to cause an undue hardship, for example, then only you can start looking at dismissal. If you are then looking at dismissal, there are two types of dismissals, we think. The first type of dismissal is an incapacity dismissal. We think that that is the appropriate dismissal mechanism if the employee is unable to vaccinate because on the basis of constitutional grounds or on the basis of medical reasons. If the employee is refusing rather to vaccinate just because they don't feel like it, and you've now established this rule, we think that that is a misconduct dismissal on the basis of a refusal to obey a lawful and reasonable instruction. And that is really where you will have your mechanisms. Of course, once employees have been dismissed, they can challenge their dismissals, and we think that their dismissals can manifest in general unfair dismissal or automatically unfair dismissal. That's the one that is linked to the grounds that are akin to the unfair discrimination grounds. And also they can potentially challenge you in terms of the Employment Equity Act, challenging the conduct as one that is amounting to unfair discrimination. Again, that risk assessment becomes handy, because if you can justify the fairness of your conduct, taking into account the operational requirements and the risks that the business is exposed to, as well as the employees are exposed to, etc., you have a much better chance of defending any claim of that particular nature. I see it's 11:35. Now, if I could pause here for a moment and see if we can take questions, and then if there's more time at the end, I might want to supplement with 1 or 2 issues.
Thank you, Balindile, for this insightful presentation. I'll help you go through the comments and the questions that are on the chat. The first one is that, the basic conditions of employment did not really take into consideration the new way of or the new normal of people working from home. And the question is, are we likely to see changes in the corridor, for example, and the EHS, to accommodate some of the things that you've spoken to, your remote working? So do you anticipate any changes in legislation? That's the first question. The second one is related to vaccinations, and you've spoken to it at length, but maybe you, just to say, the question is, please share insights on vaccination policies that South African companies may have adopted. I think you've just spoken to that. How does the employer maintain confidentiality around issues of IP and data communications when workers are working in unregulated spaces? And then I think the other ones are sort of comments. And the last, the last is, workplace. And I think you mentioned that, wherever you work and there is an agreement between employer and employee, that place would be considered a workplace. So does the Occupational Health Act oblige that obliges that there should be a safe working environment? How do you deal with it when somebody is working outside of the office or in a coffee bar, like you were saying? Is that considered a workplace? And should the normal regulations also apply in that environment? Let's stop there and then we can continue so that I don't bombard you with a lot.
Thank you, Nell. So the question of whether or not I anticipate any changes in legislation, that's a heavy topic question. I haven't heard anything that requires it, but even though the BCA, when the BCA was crafted, it didn't envision this per se. As things stand, it appears to work. So the current provisions can be interpreted in a manner that gives guidance to this kind of space. Where I think there might start being conflict is if, for example, there is downtime, I beg your pardon. So say, for example, employees working remotely, and especially an employee earning below the BCA threshold, and they are busy for the first 3 hours of the day, and then there's a gap in their day where they are literally not doing any particular work, and then suddenly they're busy for 5 hours, but now we've already ticked over hour 8. There, I think there might be some gaps, but the BCA also provides some other mechanisms. There's something that's called averaging of working hours, where it permits employers with agreements with the trade unions to average hours of work. So even though you are not working 8 hours a day, if over a set period, so let's say if over a period of a month or 4 weeks or 2 weeks, you are on average working the 8 hours a day, it then calibrates and you don't have to pay overtime work. So those are some of the creative mechanisms that employers can take into account. There's also the questions of compressed working week, where employees can work for 4 days in a week at up to 12 hours a day and not have to trigger the overtime. So there's certain creativities that work around that. And then something that is not often used in terms of the BCA, I think it's section 59, or Section 50, which regulates for, which provides that a ministerial determination can be obtained exempting an employer from complying with certain provisions of the BCA. So if, as a result of this remote working model, you find yourselves with particular limitations from the BCA perspective, you can approach the minister through the Department of Labour and apply for a ministerial determination, of often loosely referred to as an exemption. And if you get them, then you'll be able to work within it. So as things stand, I don't think that there's a specific need to change legislation, because it can be adaptable, and it's only going to be when it is completely out of sync that there might be a need for adaptation. Then the next question was on confidentiality and how you regulate confidentiality in unregulated spaces. And I think that's exactly the point. If you're going to permit remote working, you're going to have to regulate how and in what circumstances it can be done. And only if you as the employer are satisfied that you can take care of your interests from a confidentiality and IT security and data protection perspective, then only you should be looking at permitting it. If it's not in your particular organization, or because of the nature of the work that you do going to be possible, then you probably might have a case for not encouraging or permitting remote working. Now, please, can you help me with the last OHS question? I have forgotten it.
I've moved away from that one. Let's check.
So I'm sorry.
It had to do with the workplace. I think it was the work environment. Would you yeah. Yeah.
Okay, I remember. Thank you very much. So in relation to that issue, one needs to be practical. And in the sense that you cannot be everywhere as an employer. So, and it's reasonably practicable. So if something is not reasonably practicable, then you would then be relieved of that obligation. But as things stand, you're going to have, as an employer, to do what you can. And like I said, one of the easy ways of doing this is just doing a policy or guidelines for an employee and having a checklist, because then you let the employee do that assessment, feedback with a commitment or declaration that the information they're giving you is correct. You then rely on that information, because when you do a desktop review, and then from that perspective, your health and safety practitioners will say yay or nay. And if it is a nay, they will say these are the things that can be done to improve it, and provided that they don't cause an undue hardship, then that should be accommodated. And if they cause an undue hardship, then that particular job function or that particular employee might well then be part of those employees who would not be permitted, or where it would not be appropriate to use a remote working mechanism. Thank you.
Thank you. I'll take one or two more. The medical issues that people might have due to poor working conditions at home. Can the employer be held liable under COIDA? And would that be a successful claim? And the issue of work permits. So if somebody work permit out of the country for virtual work, is it really required? So if somebody is based in London and they work for ENS, do you have to give them a work permit, or is it dependent on the fact that the domicilium or the registered company is in South Africa? So what are the work permits issues there? And do employers have to subsidize employees for things like electricity? I know you talked about giving them the relevant tools of the trade, your data, your equipment, whatever. Issues like electricity and other overheads, is that a requirement for employees to actually pay for that as well? Thanks.
All right. So let me start with the last one. From the question of subsidization of employees for costs that are associated with doing the work, that's something that an employer would have to take into account. So again, I say, if the employer requires employees to work from home, then the question would be, is there an allowance? In the same way that we used to seek our allowances, is there an allowance given for the costs associated from working from home? So paper, for example, with printing is required. Or are you going to say this is your total cost to company and embedded in this is whatever those costs are, or you're going to have a reimbursement mechanism? The tricky thing, or what would have to be considered from a reimbursement mechanism, is how do employees prove, for example, that this portion of my electricity bill is associated with work? So and there isn't a specific laws that regulate this. So it's going to be part of what will be negotiated between an employer and an employee. But where I think those discussions will be most prevalent is when there is a conversion. And it might well be that if this is at the instance of the employer is going to have to give a bit to get the consent of the employees to agree to a working from home or remote working regime. But if this is at the instance of the employee, again, it becomes less of a burden, because what the employer has done is it's provided a suitable work environment in the office, and the employee says, I'd rather work at home. And the employee said, well, I'm happy to accommodate you, but you just need to make sure that you are suitably equipped for it, and then that is at your cost. So there's not a one-size-fits-all approach. It will have to be considered holistically. In relation to the issue of work permits, there's not a one-size-fits-all approach. You're gonna have to consider the immigration laws of the country that the person is working from, and the countries, the receiving country. So if, for example, we are the receiving country, we need to look closely at our immigration laws. And I'm afraid I don't have the answer immediately, but from my understanding is that there's a certain trigger, and I'm happy to just circulate that after my on the chat immediately after my session, which would require obtaining a work permit from a South African perspective. But it's not as simple as that. It depends on which countries are also involved. No?
Okay, thanks, Balindile. I think you've dealt with most of the questions. One just came in now, and it might be of interest. I'm going to keep everyone for just one more minute. How can deal with issues that affect employees' and productivity that's out of their control, such as load shedding? Do employers have a right to withhold remuneration for hours not worked? What would be the correct recourse?
All right. So we've dealt with productivity. I think but from I think an important question you're asking, whether employers have a right to withhold remuneration for hours not worked. The framework in South Africa is that an employer and the duty of an employee is to tender their services to the employer. Once those services have been tendered to the employer, it is on the employer whether or not to utilize those services. So if an employer does not use those services because they don't have enough work upon the tender, then the employer's reciprocal obligation to pay still remains. And that's why I say that if you're going to have, if you're not going to be able to fill up your employees' days with productivity, then you might not want remote working, because once an employee has tendered their services, you must pay them. And if you don't use them, that one is on you. So that is the one sensitive part about it. So from a recourse, I think what you may have missed the earlier part of, I said that as an employer, you could want to have a look at getting exemptions if you are going to want your employees to work extra hours to compensate for the downtime. I keep saying downtime. I beg your pardon. Thank you, Nell.
Thank you. I think we left one out: long-term medical injuries and COIDA question not addressed. Can we please advise on that one? And I'll check the question once again to remind us. Sorry, I'm going up.
So just from a general perspective, never whilst you look, COIDA is applicable for any occupational illnesses and diseases. So to the extent that the illness or the injury is accountable to the employee's performance of their job, then they would be entitled to a claim. directly to COIDA, and the important mechanism about COIDA is that where an employee can claim from COIDA, the employer is then exempt from liability because COIDA is actually it's an insurance. So the most important consideration is that occupational injury, or rather is that injury or disease arising out of the cause and scope of the employee's duties. So, and it does become a difficult one in the context of remote working, because if you are walking up your stairs and you trip, is that part of your job? But so that one's tricky because you just got hurt in your home. But if, for example, you are moving from your desk to pick up a paper or a file and you trip over your laptop cord, for example, that becomes closer in my mind to an occupational injury. So the facts then will become quite important.
Thank you. I think you've actually hit it on the nail. That was the question. So thanks to you, Balindile, for the presentation and for answering questions and dealing with very critical and pertinent matters.